Honorable Vice Chancellor, dignitaries on the dais, ladies and gentlemen. When the 1929 stock market crash took place, there was little hope of recovery. But then a great president came along, Franklin Roosevelt, and he inaugurated what was called the New Deal era, New Deal legislation. And at first, the Supreme Court kept stalling everything that he tried to do. That's the Supreme Court of the United States. And finally, fortunately, in 1937, with the West Coast parish case and several other judgments, the Supreme Court enunciated a proposition which has been followed till today, which is that in the economic sphere at least, there should be a judicial hands-off unless there is something so arbitrary and unreasonable that it is necessary then for the court to intervene. Otherwise, to experiment is the prerogative of the executive. And it is in this spirit, as a matter of fact, that I started delivering judgments on this great insolvency code, because I realized that it was a new experiment and it did away with the 1929 crash that had taken place in our country in the form of old legislation. But it's important first to tell you what that old legislation was, to show you how great an innovation this was. First and foremost, if there were companies who were unable to pay their debts, they went straight into winding up, short of schemes of reconstruction which could be done under the old 391 of the Companies Act. And those were rare. But otherwise, a perfectly healthy corporate entity which was otherwise unable to pay its debts suffered winding up, which was a very, very serious thing. And realizing that, the first experiment was conducted in 1985, where the Industries Act of 1951 set out certain basic industries for the nation's progress. And if a company happened to manufacture things which belong to those industries, that is under that IDR Act, then the idea was at that point of time to put a corporate debtor back on its feet. And the Sikh Industries Act had a mechanism by which, once accumulated losses were more than the net worth, which was the paid up capital and free reserves, then a company was said to be technically sick if it produced goods under the IDR Act. And once it was sick, there could be a registration under Section 15 by various persons. And then a board of industrial and financial reconstruction took over. And once it took over, it sought to satisfy itself that by certain measures, it could get that sick company back on its feet. And it appointed an operating agency for that purpose. The operating agency, incidentally, was usually a financial institution. And a scheme was then proposed by which the idea was to bring the corporate debtor back on its feet. Such schemes were tardy in their implementation, and a moratorium that was imposed under Section 22 of that Act went on for the entire duration of the scheme, which usually went on for years and years without any real progress happening. So that by 2000, the Adjudication committee, which looked into this law, was able to say it was a complete failure. And out of some 3,000 odd companies which had gone in the red, only 264 or thereabouts had actually turned around. A large number being wound up and the maximum number still hanging around awaiting resolution by the BIFR. The next measure was the Recovery of Debts Act in 1993. Now the focus shifted. The original focus was on the corporate debtor. This time the focus shifted to the secured creditor, which were the banks and financial institutions. And banks and financial institutions then were now sent not to civil courts, but to debt recovery tribunals. And the idea was that this would be a fast-track process, not only for adjudication, but for recovery. Because you had a recovery certificate, and that certificate then, you could go to a recovery officer who would auction the properties, etc., and get you your money. It was hoped in a reasonable time. Even this didn't really succeed. So that finally now you had the Securitization Act of 2002, where banks and financial institutions took this into their own hands, and where there was an NPA declared. That is, an NPA was a company which met certain guidelines and was reasonably certain not to pay or be unable to pay its debts. The bank and financial institution, without having to go to the recovery tribunal, could directly go and either sell the assets which were secured with it, or have a new management, or were given huge powers. And they were also given the right to go to the magistrate to enforce these powers. Now, even this did not really succeed. So that with this background, we had this new, fresh insolvency code. The focus shifted back to the corporate debtor, like under the SIC Act, but with a huge difference. Now, what was this difference? The difference was that the old management was out for good. Under the older schemes, the old management continued in perpetuity. This time, you had the interposition of a new resolution professional. This is something that the Act created for the first time. And these were persons who were trained not only to run a SIC company as a going concern until it could stand on its feet and be handed over to a resolution applicant, but who were to oversee the entire process. So this was the first major change. The second major change was that whereas corporate democracy required that it is shareholders who appoint directors, here a committee of secured creditors comes on the scene for the first time. This is again a very, very important difference now to the law. They were called financial creditors, but they were almost all of them were secured and persons who gave loans to this SIC company. And now from the shareholders, the focus shifted to this COC, which was something new. And by a percentage, 75 was the old percent, reduced to 66, they could take momentous decisions. First, of course, the erstwhile board of directors got removed. And then they could choose which, according to them, was the best new management which should now be interposed to run the company, doing away with corporate democracy completely. Now, with these major changes, we were faced with a number of creases in the Act, because the Act, being a new measure, had to be worked out. Now, how best it was to be worked out was through case law. And as somebody just said, the first judgment, innovative, went into the objects, went into the fact that all the old law was not something which was up to the mark, and how now this new law had to be worked. Now, first and foremost, the trigger point at that point of time was only 1 lakh of rupees. Today, it's been raised to 1 crore. So, any financial creditor, now financial creditor again was a new concept. You had secured and unsecured. This time, it was divided into those who gave loans and those who had debts because of certain services or because of certain goods sold. And you had this neat distinction made for the first time. And there were different trigger points. So under Section 7, the financial creditor could trigger the code, provided, of course, that the debt or the default due was over 1 crore now. And he could also, for the purpose of that crore, tote up other financial debts. This again was very, very important. And this was in the explanation to Section 7. So it wasn't just his debt. The idea, therefore, was that this is not a debt recovery mechanism at all. The idea was that you would make a distinction now between the corporate debtor and its management, get rid of its management, saved the corporate data from its management, so to speak, and interpose another management to see that finally every stakeholder benefits, which includes the shareholders, which includes the workmen, and of course, which includes the creditors above all. Now, given this new scheme, it was enough that a financial creditor showed a default. However, for an operational creditor whose debts were usually unsecured and of a much lesser amount, they made it much more difficult to trigger the code correctly. Because an operational creditor could only trigger it if ultimately the company was able to show that there was no dispute with the debt at all. And the dispute didn't have to be of the old type where you had to show you are likely to succeed in point of law. It's enough that there was a dispute, which was not sham. So these important points were adverted to. Above all, the most important point was that you are now getting all the insolvency laws under one umbrella. Now, unfortunately, in practice, that has not happened. For some reason, we are now in the 9th year of working. The insolvency laws, the old Presidency, Towns Insolvency Act and the Provincial Act continue. And this part 3, which should have taken over with a resolution professional interposed, has somehow never been brought into force. That's one thing that will require attention as soon as possible, and attention to see as to why it has not been brought in force. Perhaps it requires a little tweaking also, legislatively speaking. So even though the idea was to bring everything within one, we still now have in operation 3 insolvency acts. Apart from this, you also had the timeline, which was of extreme importance. Now, the idea was to try and get this corporate data back on its feet, but within a time frame. And the difficulties of the time frame were, originally you had 180 plus 90. That became 180 plus 90 plus 30 and then plus 30, finally. So it became ultimately 330 days. With, of course, experience and working. But the difficulty here was what happens when nobody is responsible for the delay, but the tribunal is responsible. And that is something which, as a judge, one felt had to be excluded. And if that was excluded, then again it would skewer the entire thing. So then ultimately the legislature said that no, we are now giving you a longer period, but you have to include these delays as well. To which again, the court went back and said, the word mandatory must be cut out. And you must see, and I think this is the correct position ultimately. If the delay is due to the tribunal alone, then it has to be kept out. But if it is due to a party asking for adjournment, then perhaps it can't be kept out. So this again was the other important focus that the very first judgment spoke of. Now, Mobilox was the next judgment, in which again there was a slight crease in section 8.2b, because 8.2b spoke of suits and other proceedings and disputes. Now, the word and was a misfit. So we read it as or. And this reminds me of that old ditty. I am the parliamentary draftsman. I compose the nation's laws. And of half the litigation, I am undoubtedly the cause. So this is what has happened with a large number of provisions of the code, which the ruptures had to be smoothened, so to speak. And of course, it was an amazing thing that there was almost a partnership between the court and the legislature, largely because you had a committee which was ongoing and which was looking into the working of the code. And this partnership yielded a lot of fruits. One of the fruits being that the moment the court suggested something or struck down something, the legislature followed and ultimately added or itself. And it did that in many other things. So the first 2 judgments themselves dealt with how the code could be triggered, what was the newness of the code, what was expected of the code, and how once the corporate data got back to its feet, you had huge funds which were infused back into the economy after the failure of all the earlier acts. Then, of course, you had that State Bank of India versus Ramakrishnan, and that focused on one other interesting feature of the code, the moratorium provision. Now, Section 14, which is the moratorium provision, is a very, very widely worded provision. Because not only are all suits and proceedings interdicted, no transfers can be made of assets, and whatever occupation or possession of the company gets frozen. So that whoever the landlord may be, he's out for the time being. But the silver lining in the cloud is, this is not like a Section 22 moratorium. It doesn't continue right for the duration of a scheme which was unending. This continues only until finally there is a resolution applicant who is handed over the company by the adjudicating authority, at which point it comes to an end. And again, the court had said, personal guarantees are outside this, which is an important thing. The legislature again amended the law and said, yes, that's correct. But then this time they did something peculiar. They said personal guarantors will now have to be triggered under the part 3 of the code, which was not brought into force to individuals and firms. So you have only this guarantor now. And the other funny part is that the guarantor has to go to the debt recovery tribunal, not to the NCLT. So this again is some anomaly that has been created and which requires to be smoothed out at some point of time. This is quite apart from the guarantor, of course, losing his right of subrogation, which is again an important thing. Because if so many crores are to be recovered from him, surely he can stand in the shoes of the principal debtor thereafter to recover. But that's gone with the insolvency. So these are all things that will have to be deliberated upon in some more detail at a future point of time. Apart from this, next important judgment, I think, was ArcelorMittal. And in ArcelorMittal, it was what was adverted to was 29 capital A of the Act. Now, that was again a very interesting provision because it was very important to see that by some subterfuge, the old management which was removed didn't come back. So you had very detailed provisions to see how it did not come back. And that was the subject matter of ArcelorMittal. ArcelorMittal also said one important thing, that writ proceedings which were trying to stall the proceedings under the Insolvency Act would not lie, because the entire process would have to get over first before you were able to ventilate any grievance. And then ArcelorMittal actually set out exactly how the code worked. And this is important because the adjudicating authority had very few powers. The powers at the start were far greater than the powers at the end. The powers at the start are 3 things have to be done on the assumption that a Section 7, 9 or 10 petition is admitted. Once that's admitted, immediately what the authority has to do is, first, it has to appoint what is called an interim resolution professional, now is to carry the entire thing forward. After that, the next important thing that it does is it imposes a moratorium, which is almost automatic. So straight away it is done. And the third thing is the important public announcement to tell everybody that this is happening and that all claims must come under one umbrella. Any claim outside this umbrella is out. Once that happens, the interim resolution professional now appoints the new COC, so to speak, which is only, as I told you, financial creditors, operational creditors being left out. And they were left out for a good reason, because they would be small individuals who would not really be interested in seeing how the corporate debtors put back on its feet. Whereas persons who grant huge loans would be interested and would therefore try and get managements which would do so. So ArcelorMittal then told us that once this happened, the COC then gets appointed and the COC either continues with the interim resolution professional or appoints a new one. The resolution professional then does the most important thing, prepares an information memorandum under Section 29. That information memorandum gives all those who now want to come into management as much information as possible about the company so that they may make an informed decision as to whether they would like to come into the management of this company or not. And once they do so, then ultimately it is only the COC by a 75% vote, now a 66% vote, which is to decide as to who best should be the person to run this company. Importantly, the old management goes out for good. And a new management now comes in, only selected by this COC. And the adjudicating authority ultimately, when a resolution plan is accepted, let us say by a COC, has a very limited power. All it can do is to see two things. One, that operating creditors and dissentient creditors get their minimum due, which is what would happen if liquidation took place. And second, that otherwise it was in accordance with law. They had no jurisdiction, as did the company court in Mihir Mafatlal under the old scheme, to find out whether this was just and fair to all stakeholders. No. All that the NCLT could do was now to see that these two things were fulfilled and then pass the plan. And once the plan is passed, the moratorium gets over, the company starts with a new management on a clean sheet and moves forward. Now, one of the important things that I would want you people to address in this conference is what happens once the resolution plan starts working. It's important, of course, that it contains an entire scheme for its implementation. But suppose there is some crease, some problem during implementation. Who does one go back? Does one go back to the COC? Does one go back to the shareholders? Does one go back to the NCLT? These are not concerns that are addressed at all, surprisingly, by this code. That is something that the legislature will have to see. Because if a plan, say, takes off and it is to let's say, encompass 3 years or 5 years, and it's all right for the first 2 years, but in the third year, there's some major hitch, then what is to happen? Are you to go back to the NCLT and wait so that the hitch may then lead the company down the tube again? Are you to go back to the shareholders? Have their powers gone under the Companies Act to recall such a management? Are you to go to a COC, which is a spent force, after the resolution plan comes into force? These are very important points that need to be deliberated upon and which have not yet been deliberated upon. Now, after ArcelorMittal, you remember there was that famous Swiss Ribbons judgment. And Swiss Ribbons dealt with the constitutional validity now of various provisions. And the court made this important distinction between financial and operational creditors. Said that Article 14 would not be infringed as the two were completely different. Another major concern that I think you need to deliberate about in this conference is that the operational creditor seems to get a very raw deal. From what I am able to see, so long as the corporate, he may be a small shopkeeper, he may be an individual, and his debt may be nothing compared to the huge debts owed to secured creditors. Say the debt is something like 20,000 rupees. And under the waterfall mechanism under 53, he would get only 1,000 rupees. Why should he get only 1,000 rupees? He may be a small man. So I think the focus of the code also needs to be shifted on operational creditors and what they should get. And maybe this should be taking two parameters into account. One, how much is the debt owed? Second, the nature of the operational creditor. If the operational creditor happens to be Tata, Godrej, some huge company, maybe it's all right. But if it's some small individual storekeeper or some small individual something or the other, then why should such a person suffer when, let us say, banks, financial institutions are getting back 80%, 70%? Why should he not get back his entire debt? That's another area which you people need to focus upon so that the legislature then picks up what your conference says. Because there's an ongoing committee. So once one keeps on suggesting things to them, who knows? Things may improve. So after Swiss Ribbons then, we had that famous Pioneer judgment, where flat purchases. Now, according to me, a flat purchaser triggering the code is not going to help the flat purchaser at all. Frankly, it will hurt him. So it is far better that he goes under his own statute, that real estate statute. And if a flat purchaser does happen to trigger the code should not be triggered easily. It's triggered far too easily, according to me. Because once it comes in, then It overshadows RERA. And RERA goes out of the window. What happens to all these other poor people? You may want to get the corporate debtor back on its feet, which will take a long time. But what happens to persons who are flat holders, who have advanced these huge monies, who are hoping for a home within, say, 6 months? And then once this process now begins, it's shelved now for 6 years, 8 years, whatever. That's another important concern. So for these persons also, the triggering of the code should be made much, much more difficult. Or maybe they should be taken out of the purview. I don't know. Because otherwise, RERA seems to be good enough to look after their needs, generally, as persons who wish to get into their own homes. So this is one other important point of focus. Then, of course, you had the SR Steel judgment. And the SR Steel judgment spoke about how Hydra heads can't pop up constantly. Company must start on a fresh slate, etc. And the single most important contribution I think that judgment has made is to make it clear that's the commercial wisdom of the Committee of Creditors alone, which takes a call. Because feasibility and viability under the section are only with that Committee of Creditors. It is by no means with any adjudicating authority is not equipped to get into all these matters. So that again made an important advance in the law. Also, it was reiterated that resolution professionals, important though their role is, have no adjudicatory powers. That's again very, very important to remember. That the resolution professional is really a facilitator. That the idea is that he facilitates this whole process, and once the process is done, he stands by. And there again, I think it is necessary for you perhaps to deliberate on the role of this resolution professional, because I am hearing a lot of complaints these days. So there should be some mechanism by which the persons who come into being as resolution professionals are then monitored. And you see exactly what they have done as resolution professionals, Quay companies. If you find that they have failed in more than one, maybe you should disbar them. If you find too many complaints against them, maybe again you should disbar them. Here again, you've got to separate the wheat from the chaff, because if the salt has lost its savor, so to speak, because this is the salt, then the whole process goes for a 6. This is something else I think this conference needs to deliberate. This is again very, very important. And then, of course, you have this great Mohan Raj judgment. Now, there we were faced with what I described as a civil sheep in criminal wolf's clothing. Because the 138 proceeding is a criminal proceeding, without doubt. And under 14, a proceeding cannot be a criminal proceeding. That again is without doubt. You can't have a moratorium on a criminal proceeding. So, it was important to call it quasi-criminal, quasi-civil, and then get it under the moratorium provision, because if otherwise 138 were not within the moratorium provision, again, it would be very difficult for a resolution professional to run the company and have to pay off huge debts or bounce checks. So that interesting exercise was also done in Mohan Raj's case. And then, of course, in EBIX, Singapore, you had one other interesting facet, which was that the Contract Act gets wiped out. It has no place. This code is a self-contained code. And also that once a resolution applicant comes forward with a plan and it is accepted by the COC, thereafter, he cannot play ducks and cakes with that plan. He can't withdraw and he can only modify with 66% of the COC agreeing. Otherwise, no. That was again an important brick laid down. Then, of course, there were many judgments which spoke about how this particular code overrode many other statutes, including the Customs Act, the SEZ Act, this, that, and the other. And finally, if this code is really to work, I would suggest another very, very important change be made. Because we have many constituents who make this code work. As I have told you, it's the resolution professional who makes the code work. No less important are the tribunals. And if the NCLT is to be a tribunal worth its while, I would suggest that every bench which is situate everywhere and which is hearing, even a part of a bench which is hearing a matter under the IBC, should be headed by at least a retired High Court judge. Minimum. Today, what we find is that there are persons who are other than High Court judges who are manning these tribunals, and delays have become rife. Judgments are not corrected law. So another very, very important step that the legislature needs to take is to say that not only the NCLT but the NCLAT also should be manned only by retired High Court and Supreme Court judges. After all, we all retire at 62 and 65. We are perfectly able-bodied. And you know, again, who are the ones who work and who don't. So you pick up the right ones and you make the system work. It's a very easy thing to do. Otherwise, we don't want the system flagging at this end. You see, it flags either at the resolution professional end or finally at the tribunal end. So all this you will have to see in this conference. And I wish you all the very best. Best of luck, and take the code forward as we've tried to do. Thank you.